the hell is wrong with you? You just hit my car.
Bro, I didn't see you. You must have been texting your girlfriend.
No, the light just turned green, so I went. And I didn't see you. Look at my car and my neck. It's hurt so bad.
Man, I didn't feel a thing. Actually, I feel pretty good.
Well, my medical bills are going to be at least $18,000 to fix my injuries from the whiplash that you just caused.
Well, look at my car. You messed it up, and there's like $5,000 worth of damage to my car.
That's nothing. I have you beat there too because there's at least $7,000 worth of damage to my car. I'm just gonna have to sue you in civil court, bro.
No.
Excuse me, Mr. Young. Would you mind taking a step over here for a second, please? Have you been drinking today, son?
No, officer. I haven't had anything to drink for a couple weeks.
Are you sure about that?
Yeah, I haven't had anything all day.
Well, you're lucky, son. I don't have my sobriety kit with me right now, but I'm going to have to charge you still with drunken driving.
What? No.
Welcome to our law office, James. I'm attorney Louis Van Alstyne.
And I'm attorney Zach Trapp. We reviewed the police report and seen the evidence of the accident, but we wanted to know what you had to say about it.
Well, me and my bros were out tailgating, and then my girl called, and I had to go pick her up in my car. Well, did you have anything to drink while you were doing this tailgating thing? What do you consider drinking? Like 3 cans of beer or a keg stand?
All right, James. Just try to remember specifics. What did you drink that day?
Let's see. I know I drank at least 3 40s of malt liquor. Well, your trial is coming up next week, and conviction of drunk driving would probably mean that you would pay a large fine and lose your driving privileges for a year.
We have plea negotiations scheduled with the prosecutor this afternoon. Settlement discussions about the potential civil claims are also expected soon.
Okay, bros. Let me know soon. Thanks. You know what, Zach? We haven't talked at all with James Young about what kind of plea he might enter.
But Louis, we do have authority from his insurance company to pay up to a total of $20,000 for the combined personal injuries suffered by the other driver and the property damage incurred by the owner of the other car.
Yeah, I know, Zach, but, you know, if only I had paid more attention in my professional responsibility class and the legendary Professor Hurt, I'd know the ethics rules related to negotiations.
Good afternoon, gentlemen. It appears that the problem you are facing is that you haven't spoken to your client about what he wants out of the negotiation process. Now, I'm going to ask a few questions concerning the ethics of negotiation in general. But before I do that, let's start with what negotiation actually is. According to Black's Law Dictionary, negotiation is a consensual bargaining process in which the parties attempt to reach agreement on a disputed or potentially disputed matter. Lon Fuller said it best in his book titled Anatomy of the Law. He said, "Negotiation, we may say, ought strictly to be viewed simply as a means to an end. It is the road the parties must travel to arrive at their goal of mutually satisfactory settlement. But, like other means, negotiation is easily converted into an end in itself. It readily becomes a game played for its own sake, and a game played with so little reserve by those taken up with it that they will sacrifice their own ultimate interests in order to win it. Now, class, I will ask you a few questions concerning the negotiation dilemma and the co-counsel, Zach and Louis. If you'd be so kind, please raise your hand with a suggested answer. Question A1. Who and or what gives you the authority to conduct negotiations on behalf of your client. Turn your book to question A4. Should a lawyer be required to tell the client about all settlement offers received from the other side? Who wants to answer that? Good, very good. Question B1. When I start to discuss the case with the prosecutor or the opposing counsel in the civil case, may I assert that Young had nothing alcoholic to drink on the day of the accident? It's an ethical question. Question B2. Are all lies created equal? Are some lies tolerated, some even encouraged, while other lies are forbidden? Question B4. Is deception and withholding of information inevitably good negotiating strategy? Question C1. Do you have an obligation to the opposing party to disclose facts that would be harmful to your client, such as the death of your client? C3. In a criminal case, how candid must a prosecutor be about the strength of the evidence? Now here again, this is another rule. Y'all should know this. Question D2. This is a long one, now pay attention. In the course of defending James Young, you have discovered that the city often has problems with its alcohol detection kits. This is information the city would prefer to be kept quiet. Now assume the city proposes to drop all charges against Young in exchange for your agreement never to defend another drunken driving case. Do the model rules permit you to get Young off the hook on that basis? Question D4. This is another long one, but I promise this is the last one. We have one lawyer and two clients in this. It'll help you out with the facts. Now assume the insurance company has authorized you to pay $20,000 to settle a total of $25,000 in claims. In other words, they haven't offered enough money. May counsel for Young's opponents negotiate a settlement that would pay the other driver $18,000 for his personal injuries and then tell his other client, the car owner, that there is only $2,000 left to pay for the property damage? Now, the counsel is representing two plaintiffs as separate parties in the same case. Think about it and then let me know what you think. Well done, class. Well done, counsel. Very good job. Very good job. Thank you. Now, who's next?